We're going to talk about transmutation law, and the name of the program is going to be mine, yours, ours. You don't really know what it is. Some of you might have friends that think that they own property, and they may or may not. And I'm going to tell you that it's not as simple as looking at a deed. There's a lot of complexity that goes on with evaluating married people as to what they own, who owns what, are there reimbursement claims of that nature. So today I'm going to very quickly go through the law with you, give you an understanding, and hopefully after today, when you're talking to somebody in your business, you're going to look at it a little skeptical. You're going to ask some additional questions because it's not a surface level thing if you're talking about whether or not you own property while you're married. So let's first take a look at the overview and statutory framework. Transmutations, what is it? It's a spouse's agreement or transfer that changes property legal character. There's three directions: community to separate, separate to community, or one spouse is separate to the other. And this is all going to be anchored in Family Code Section 852 et sec, which requires an express written declaration of the intention of the person who's doing the transmutation. Now, the law is boiled down to these codes here. 850 allows, this is Family Code Section 850. It's a transmutation by agreement. 851 subjects it to the fraudulent transfer law. 852 demands a written express declaration, plus recording for real property as to third parties. And then there's 760 of the Family Code, where there's a presumption, regarding fiduciary duties, and 2640 right of reimbursement. That's very quick, and we're going to hopefully have some time to get into these things so you'll actually understand it. The bottom line is that after 1985, no transmutation from separate property to community property is going to be valid without a signed, written, and express declaration. Let's take a look now at the anatomy of a valid writing. So the rule is that the writing must expressly state characterization or ownership changing. There's no magic words that are required, okay? So the law doesn't get that nuanced, but the change must be unmistakable on the document's face. And you're going to see a lot of deeds. A lot of you deal with lots of different types of deeds. Some of them on their face will constitute a valid transmutation on paper, others won't. But the language is very important. So there's no magic words, but here's what the Court of Appeals have stated. People don't fall into transmutations. It's not an accident. It's something that's very intentional by the person who's making the transmutation. And unlike other contract disputes, extrinsic evidence to supply a missing declaration, missing evidence, it's not going to cut it. It's got to be within the four corners. A clear interspousal transfer deed is one of those deeds that's a safe harbor. Okay, we know that that's got the proper language in it. But there's other type of deeds that have qualified according to the courts of appeal, such as grant deed and some quitclaim deeds. The practical test is if the deed could also mean estate planning, management, or lender accommodation, is going to fail. I provided a chart. I don't know if you could see this clearly, but there's a lot of examples of writings that have failed. Grant deed to spouses as joint tenants, valid express declaration, that's going to be valid. Then there's the interspousal transfer grant deed, valid, but still analyze the undue influence. And then, there's a case that, if I get to it, it's called Wozniak, and it talks about a rejected deed. And then, finally, the best practice is standalone signed voluntary transmutation agreement is the only way that this is going to pass. Okay, now there's lots of failures, a lot of appellate court decisions. The reason why I'm putting these up here and not going through them because I don't have enough time with this, but it's almost like a case-by-case basis. We're always waiting for the next decision to come out to see, what the nuances are. And my firm was involved in one of the cases that went up on the Court of Appeal, and we'll hopefully be able to cover that. But here's an example. An IRA beneficiary consent without waiving ownership fails. Claimed oral exchange with no writing fails. Brokerage transfer journal instructions ambiguous, it fails. Okay, so now let's talk about who's got the burden of proof in these cases. And that's going to be pretty simple. And the proponent must produce an 852 compliant writing. So it's the person that is stating, hey, I think that there's been a transmutation. You have the burden of proof. And the advantaged spouse must rebut automatically Family Code Section 721, which talks about the undue influence presumption. So in 99% of the cases, when we're dealing with a transmutation, there isn't valid consideration. You know, they're not getting a lot for those deeds and stuff. And so you already start off with the presumption that there is undue influence, and we have to work our way backwards if we're the person who's saying that there's been a transmutation. So the common defenses against transmutations is there's no writing or declaration, ambiguity, no acceptance, undue influence, fraud, duress, or mistake. It sounds very familiar to the lawyers here when you're talking about like contract disputes. 721 imposes the highest good faith and fair dealing between spouses. When we talk about the fiduciary duties between spouses, it's the same or if not higher than in business transactions. Gaining an advantage shifts the burden automatically. So the burden is to show that the transfer was free, voluntarily, and fairly understood. Okay, now I'd like to talk to you about a couple of cases that I think will put some gloss on all of this. And the first one is the Valley decision. And we're talking about, yes, Frankie Valli and one of his wives. This dealt with a question that really lingered for a long time, and the Supreme Court had it for about a year before they actually published their opinion. This was a 20-year marriage. The parties separated in 2004. In March 2003, the community funds bought $3.75 million worth of life insurance policy. And I like to say that Frankie Valli did that for his wife, influenced by that song, Who Loves You Baby, right? You know, who's gonna take care of you in the night, you know? Well, unfortunately, his marriage to this wife didn't last. And, you know, she started during the divorce process saying that's her separate property. So this is going to be a case where she's going to claim that the insurance money is hers because the title of the insurance policy was in her name. When he bought it, it went into her name, okay? And he's going to say, no, it was purchased during the marriage, and so because of that fact, the community property presumption will prevail. Husband's arguments were that all that money means that the fact that community funds purchased it means that there was never a valid transmutation. Wife saying, oh, you know, title in my name, bought from a third party. It's clear as a bell. I mean, you never intended it to be anything but mine. So the governing legal standards is 760 of the Family Code. It presumes property acquired during the marriage is community. And the exceptions are pre-marriage, gifts or inheritance are traceable to a separate source. Transmutations, again, requires a written signed agreement, and the court prioritizes the statutory scheme over the title presumptions. Okay, so that's the basic legal framework that the courts dealt with when they made this decision. And the Supreme Court held that the policy stays community property, no written declaration, no transmutation. So in essence, what the court said is that community property will always trump title. Okay, so you know, don't even start with the title. Now, there's some cases where title was important in determining it was a separate property asset, but community property is what trumps, and that's why Frankie Valli prevailed. The practice tip here is, you know, if you're talking to somebody, make sure that it's in writing, make sure that it's clearly intended. And for my sake, I think that there should be an attorney on both sides of the transfer. Okay, now this is the case that my law firm dealt with. We handled this case. We were representing the husband. It was Bejian versus Saragian. And the question is whether there was a clear writing of a spouse's intent. And this was a case that had a lot of different types of deeds. And I'll go through them very quickly with you. On April 29, 1996, the grandmother, the wife's mother, quitclaims 48% interest in her residence to her daughter, and she kept 52%. The husband agreed, and he signed a separate quitclaim deed of all of his interest to wife as her separate property. However, they loved him so much that several years later, grandma and wife grant their interest to grandmother, wife, and husband as joint tenants. And the result now is that the husband holds a community property interest in the residence. If this was a grant deed, there was never a question that that was a valid transmutation in the appellate court decision. On May 1st of 2006, grandma, wife, and husband sign a trust transfer deed for no consideration to wife, and it recites a bona fide gift exempt from documentary transfer tax. Well, unfortunately, their marriage doesn't last either. December 19th, 2014, wife creates a separate property trust, herself as trustee, the children as beneficiaries. She signs another trust transfer deed, moving the residence into her trust as her separate property. At trial, the husband argues the trust transfer deed lacked an unambiguous declaration to transmute his interest. It was executed as estate planning with no mention of changing his property rights. Wife argues the grant unambiguously changed the husband's interest from joint tenancy to her separate property, and the deed couldn't transfer to her trust because the trust didn't exist at the time. Well, the trial court sides with the wife. And this was actually the Pasadena courthouse judge that we were in front of a lot. She says that this was a bona fide gift, it was an express declaration, and it was a valid transmutation back to the wife and her trust. So on appeal, the Court of Appeal reverses, and it states that 852 says there's got to be a valid transmutation in an express written declaration. The writing must expressly state the change without extrinsic evidence, kind of what I've just told you. A conveyance open to more than one meeting fails the express declaration, and here it shows that the intent to transfer some interest, but not really which one. It doesn't really say what he was trying to transfer. In fact, what the Court of Appeal stated is that it suggested moving his community property interest into a trust without changing its character, okay? And without extrinsic evidence, we don't really have the benefit of knowing anything else. So this was not a valid transmutation. And what we learned from this decision is that moving property in and out of trust has no bearing at all, no matter how you want to title it, as far as what the characterization is. It's not a transmutation. A lot of times, people come to me and say, I'm safe, right? Because, he had all this separate property coming into the marriage, and guess what? 10 years into the marriage, we put it into our family trust. It's mine, right? No, sorry, it doesn't change it at all. Now let's take a look at how the defense of undue influence plays out in these cases. Now this is a really big one because, you could have a valid transmutation on paper, and you think that you got it, but that's just the first step. And as you're going to see, there's 2 or 3, 4 different steps that we have to go through before we could actually predict how this is going to turn out. And probably the biggest one is going to be undue influence, because I already told you that if somebody's transmuting their separate property to the community or otherwise, then we're talking about, possibly a breach of fiduciary duty. So there's this presumption that has to be overcome. So these are the cases that we have where the presumption was rebutted and the transmutation was upheld. A quitclaim for lower mortgage rate signed freely and knowingly, the Court of Appeals said, yeah, that was valid. Burkle, independent counsel and negotiation overcame the presumption. That's why I say that there should always be an attorney on both sides of the equation. You shouldn't have one attorney doing this. Substantial evidence of voluntarily informed consent on the other case. So these were upheld. There's a long list of ones where it wasn't. Haynes, 721 overrides the title presumption. A quitclaim signed under duress. Delaney, a cognitively impaired husband. There was a case, I don't know if it was this case or not, but the wife was very experienced in the law. She was like the senior paralegal. The husband had no experience at all in dealing with transactions. And the court was convinced that there was undue influence. So now let's talk about whether or not there was a contract. Was there a contract in the case? Because we learned from this next case, which is Wozniak, is you also have to look at it as a contract. It's not just a transfer of a deed. The wife owns separate property in La Mesa. During the marriage, she converts title to joint tenancy with the husband. In 2006, the husband executes an interspousal transfer deed of his community property interest to his wife. Well, the wife rejects the deed. It then sits unused in her drawer for the next 6 years. Unfortunately for her, in 2012, she's arrested for domestic violence. The husband gets a protective order excluding her. She sneaks into the residence, though, while she's out on bail, removes the deed from his drawer, and then runs to the county recorder's office and promptly records it. In the dissolution, they dispute the La Mesa property. Wife says separate, husband says community. A 2-day trial follows, and the wife testifies his name was added only to refinance the loan. Well, the husband says he signed the deed hoping to end the conflict because she was always talking about it. It's got to be ours. And as evidence of that, he says, look, I put her on my property. That's why I did it, because she wanted everything to be co-owned. And by the way, when I handed it to the deed back over to her, the one that was in that drawer, she rejected it. She says, I don't want that. I want everything to be co-owned. Well, the trial court found that the husband was more credible. There's no transmutation. When he presented the 2006 deed, she rejected it. No intent remained when she recorded it in 2012. So the property, her property, was now considered community, and she had to pay him a huge equalization payment for his part of it. She appeals, and the Court of Appeal affirms, and it basically just reiterates what the trial court stated, is that there was never undue influence because there was no valid transfer here. The wife rejected the deed, and this is kind of the thing, is you can't force somebody to take property. It's got to be in an agreement, right? So, the thought is that, well, he signed it over to me. I didn't have to accept it at that time. That's not what the Court of Appeals said. Is that, you didn't reject it. The testimony of the husband is more credible because you put it in a drawer for 6 months, or for 6 years, I mean. And so, therefore, there's no transmutation. Now let's shift to the rights once characterized as resolved. And I'm almost finished. I'm going through this pretty quick, thank goodness. So I already talked to you about the steps, right? Is it a valid transmutation on paper? Is it within the 4 corners? Number 2, is there fraud or duress? Okay, we covered that. The next step is are there some reimbursement rights? And this is the thing that just kills my clients sometimes, is even if there's a valid transmutation on paper, there's no duress. The court says there's no duress. You still have to get to the reimbursement rights. So there's 2 types of reimbursement rights that play into these cases. More Marsden is one where the community acquires an interest in the separate property when it pays down or pays down the principal of the separate property during the marriage, and the value appreciates in value. That's more Marsden. Now, not all properties appreciate in value, so there's not always a more Marsden, but a lot of times in this day and age there is. So even if there's a transmutation, the court has to go through that and give the community back its interest by way of more Marsden. The flip side of that coin is 2640 right of reimbursement. So a wife or a husband might say, you know what, it was transmuted to me, right? This is all ours now because he signed the deed, there was no fraud, it's there. Well, unfortunately for the person who thinks otherwise, 2640 of the Family Code states that unless you put in writing that you're transferring all of your interest in the property as of the date you signed it, you still maintain that interest. So hypothetically, if you're in a 20-year marriage and you sign that deed on the 19th year, you're going to get your separate property interest as of the date that you signed that deed, and there might be very little community interest left over. So as I said at the beginning of this, it's like a 4-step dance or something. You have to look through all the different permutations here when you're trying to determine whether or not somebody really has a community interest, in property that was owned by the other person and stuff. So what I would say is try to think of it methodically. Is it valid in writing? Was there duress? Was there any type of fraud? Is there reimbursement claims? How big are those reimbursement claims, and who gets them? Is it the person who has the separate property, or is there this more Marsden calculation? Okay, hopefully I educated you a little bit, and you could use that for your own good. So thank you very much.